State Law Exposed, where real people, real laws, and real money collide. Every story you are about to hear happened right here in Florida, under real statutes, in real courtrooms, with real consequences. These are the laws that nursing homes, care facilities, and their parent companies are praying you never Google. If you have ever felt outgunned, outlawyered, or just plain left behind by the system, you are exactly where you need to be. This is State Law Exposed. Her mother was 82. She had just been discharged from the hospital. She needed care. She needed a place to go. Today, the nursing home's admissions coordinator placed a stack of documents on the table. She walked through them quickly. Patricia signed them all. 8 months later, Rose had stage 3 pressure ulcers. She had lost 22 pounds. She was found unresponsive and taken to the emergency room. Then she died. When Patricia hired an attorney, the nursing home did something she did not expect. They pulled out that stack of documents she had signed. They pointed to one page buried inside it, and they said, "You waived your right to a jury trial." Florida law says something different, because the question Patricia should have asked at admission, and the law that backed it up, recovered $775,000 and voided that clause entirely. When Rose was admitted to a skilled nursing facility in Boca Raton, the admissions coordinator placed a stack of documents in front of the family and walked through each one quickly. It was a stressful day. Rose had just been discharged from the hospital and needed placement immediately. Among the documents was a pre-dispute arbitration agreement. It was framed as standard and required. Patricia signed it. Her mother was 82 and not competent to sign anything herself at that point. 8 months later, Rose developed severe stage 3 pressure ulcers, preventable wounds caused by inadequate repositioning. She lost 22 pounds. She was found unresponsive and taken to the ER. After she passed away, the family discovered the extent of her suffering through her medical records. Patricia hired an attorney. The facility immediately invoked the arbitration clause. It argued the family had waived their right to a jury trial and must resolve all claims through private binding arbitration using an arbitrator from a panel the facility's parent company maintained. The arbitration clause was designed to accomplish exactly one thing: keep Rose's story out of a courtroom. Private binding arbitration means no public record, no jury of community members hearing how an 82-year-old woman developed stage 3 pressure ulcers because she was not repositioned. No transparency. The facility's parent company maintained the arbitration panel, meaning the entity being sued had influence over who decided the outcome. The gap between what arbitration would produce and what a jury trial could produce was enormous. Patricia's fear was real. She had signed the form. She had not known she could refuse. The admissions coordinator had never told her that Rose could be admitted, even without the arbitration agreement. The form was not presented separately. It was buried in a packet of routine admission documents, treated as just another page to initial and move past during the most stressful hour of Patricia's year. Florida Statute 400.0234, which governs nursing home admission agreements, explicitly states that arbitration agreements must meet 3 requirements. They must be voluntary, they must be presented separately from other admissions documents, and they must contain specific language informing the resident or their representative that signing is not a condition of admission. The arbitration agreement Patricia had signed met none of these 3 requirements. It was not voluntary, it was presented as mandatory, it was not separate, it was embedded in a packet. It contained no language stating that Rose could be admitted without it. Patricia's attorney filed a motion to void the arbitration clause based on 400.0234 non-compliance, arguing the agreement was procedurally unconscionable, obtained under duress, during a medical emergency, without the required disclosures from a family member who was not properly informed of her right to refuse. The court agreed. The arbitration clause was voided. The jury heard Rose's story. They reviewed the repositioning logs with their documented gaps. They heard from a wound care expert who testified that stage 3 pressure ulcers of this severity are preventable with standard nursing care protocols. They saw the weight chart showing 22 pounds lost over 8 months. They heard Patricia describe the day she found Rose unresponsive. The jury returned a verdict of $890,000. Post-trial motions reduced the award slightly, and the case settled before appeal at $775,000. The lesson for every Florida family placing a loved one in a nursing home: you have the right to refuse the arbitration agreement without affecting admission. Florida law requires that right to be clearly communicated. If it wasn't, the agreement may be voidable. Before you sign anything at a nursing home admission, ask plainly, can my parent be admitted if I don't sign this? The answer, under Florida law, must be yes. One family, one form, buried in a stack of papers. One nursing home that bet it would never have to answer for what happened to Rose. Florida 400.0234 requires 3 things. The agreement must be voluntary, separately presented, and must state clearly that admission is not conditioned on signing. This agreement met none of them. The clause was voided. The jury heard the case. They awarded $890,000. It settled at $775,000. Rose's suffering was not kept quiet, not this time. Ask the question at every nursing home admission. Can she be admitted if I don't sign this? The answer, under Florida law, must be yes. If anyone tells you otherwise, do not sign. Call an attorney first. The form was 1 page. The law that voided it was 3 requirements. Every Florida family has the right to refuse. Florida law says that right must be communicated clearly, separately, and in writing. If it wasn't, the clause may not be worth the paper it's printed on. Knowledge is the only equalizer, and State Law Exposed will keep getting it to you every single week. If this episode changed how you see nursing home admissions, hit that like button right now. Share it with every Florida family that has an elderly parent. You never know whose life you might be changing. New stories drop every week. Real law, real stakes, real people. Until next time, stay informed, stay protected, and never let them tell you the law isn't on your side. This has been State Law Exposed.